which concerns a sprawling topic, the legal environment for the emerging field of security research. I'm going to introduce our moderator, Andrew Tannenbaum, who is currently IBM's Chief Cybersecurity Counsel and the first to hold that position. Andrew previously served as Deputy General Counsel for Cyber at NSA. Previously, before that, he served as counsel to the Assistant Attorney General for National Security, so National Security Division. He was Deputy Director of the Guantanamo Review Task Force. He worked at OMB. He worked in Civil Division. He worked at OLC. Wow.
Basically, I can't hold a job.
Exactly. Notice he just keeps moving on. What will the future hold? We'll find out. Maybe a career as a moderator of panels. Let's see how it goes.
We'll see how it goes. Thank you, Bobby. We really have a terrific, incredible panel of experts today to talk about security research. I think we'll have a very informative and lively discussion as the prior panel on a tricky issue. White hat research, security research, it's an essential part of the cybersecurity ecosystem. Certainly as a company, it's a best practice to do pen testing of your own systems, ethical hacking, and even outside companies, people out there finding vulnerabilities in products and services are doing a great service that benefits everyone if done responsibly, and we'll talk about what that means. But there are legal risks to these activities. It is sometimes hard up to a point to tell the difference between somebody engaged in these activities for good intentions and somebody engaged in these activities for bad intentions. And the laws, the CFAA, Computer Fraud and Abuse Act as an example, are written in a way that are sometimes broad, and certainly I think there's broad agreement that technical applications of those laws could capture some of this activity. Those laws may or may not be being enforced that way, but it still poses some uncertainty for this community. And it's a challenging, it has proved challenging to draft laws and to come up with policies in this area that don't unintentionally or chill this type of activity, or at least raise the concern that it's going to unintentionally chill this type of activity. Even when everyone agrees, the Department of Justice and others, that they don't want to chill legitimate security research. This is important. There's still that concern. This last year, 2015, was, I think, a pretty interesting year for security research. You had the Wassenaar rule proposed by the Commerce Department that took a lot of heat. You had new exemptions under the Digital Millennium Copyright Act. You have the NTIA process that Allan is running to coordinate security, vulnerability disclosure, and coordination. You had CFAA amendments that were proposed, not passed, but a lot of discussion about those. The Justice Department, in several pretty significant ways, came out and made statements that they don't intend to prosecute legitimate security researchers. That's not their intent. They want to encourage that type of activity. And you had CISA pass at the end of the year, which certainly has some tools in it, monitoring authorizations, defensive measure authorizations that could be used in this context. So we'll talk about the legal landscape, some of those activities, what's on the horizon for this year. And I'd like to turn first to Jennifer to ask you, and others can chime in after you, but give us a kind of a sense of the lay of the land of the legal risk here in this area.
Sure. So I have some slides because they're actually going to make things a little bit quicker for me. It'll stop me from having to read statutes or anything. But basically I want to make 2 points. One is that offensive security research is really critical, and we don't know how to develop good researchers in that area. And so it's fragile, a fragile supply line. And 2, that fragile supply line faces extreme legal risks. And in Andrew's introduction, he used a lot of normative words: white hat, legitimate, responsible. So first let me say that those have nothing to do with the legal risks. Those assessments are per individual assessments. They have nothing to do with the legal risk. And let me also say that there can be, among maybe reasonable people, very different ideas about what's responsible or legitimate or white hat. But in the end, the upshot of it is that society needs this information. And if society doesn't get this information, our cars, our medical devices, our voting machines, our computers, our phones are all going to be insecure. So this is beyond legitimate and responsible. This is about getting critical information for people's safety, for our economy, for everything out there and developed and out there. So who are these people who are the security researchers? I know people who were kids in their mother's basements. They got recruited, went to NSA, and then they came out and they started security companies. I know people who were in hacker gangs, who had exploit tools. They managed to turn their gang into a company. The company got bought by a bigger company. The bigger company got bought by a bigger company, and now they all work for Cisco. I mean, I know people who got their start in academia, who got a degree, went through academia, learned to do security research that way, and wrote papers, and are either still in academia or out in the private sector doing this kind of work. So this is an immature industry. It used to just be hackers, and they were kind of thought of as criminals. Then it was security researchers or coders, and now I think everybody realizes that hackers is actually a good thing, and that this is a real business, but it's a new business. It's a very new, fragile business. We didn't really have this 15 or 20 years ago, and we critically need this talent, and we need to figure out how to develop it because we don't really know how to get good people in offense and in defense, maybe even particularly in defense. But we need to get good people. And yet, what kind of challenges do these people face? So let me tell you a couple of stories. In 2005, the United States Attorney's Office prosecuted a guy named Brett McDaniel. He was my client. That's how I know all these stories. They were my clients. And McDaniel published a website that informed people that this unified messaging service, get your emails, get your text messages all in one place, was insecure. And they prosecuted him under the Computer Fraud and Abuse Act. And the Computer Fraud and Abuse Act is on the screen. I don't have to read it to you, but basically what they argued is that when McDaniel put up a web page that told people that the thing was insecure and that it could be hacked, he was transmitting information that interfered with the integrity of the computer system. Information, like truthful information, was interfering with the integrity of the computer system. And more than that, they convicted him. And he did 16 months in prison for this. And then on appeal to the Ninth Circuit, in the first time this has ever happened to me or anybody I know who's a criminal defense attorney, the Department of Justice admitted they were wrong. That actually, you can't do that because First Amendment, and that's not what the thing means. It means transmitting information to a computer, not information to people. And so they dismissed the charges against him after he'd spent 16 months in prison. They then filed charges against him in New Jersey for an older case that they had decided not to prosecute, prosecuted him for that. Those charges were eventually dismissed, and Mr. McDaniel no longer lives in the United States. You can wonder why. Very often when I tell this story about the CFAA and also about copyright law, people say, well, why don't you just get permission? Because it's an authorization-based statute, just get permission. A good guy would get permission. And let me give you some examples of hacking that happens without permission. Medical devices and insulin pumps, voting machines, security vulnerabilities in cars and in the Internet of Things, looking at websites to see whether they're taking your private information or installing malware on your machine or tracking your websites. These are all kinds of security research that are done, that have to be done without permission because the companies don't necessarily want you to know what the truth is about their security. Here's another company that didn't want my client to tell about the truth about security, Cisco. In 2006, I represented Mike Lynn. He wanted to give a talk at Black Hat, the biggest computer security conference that's for where researchers present their research here in the United States. And he wanted to talk about how he found flaws in the Cisco routers that let people take over the very machines that the internet backbone runs on. This was a big deal because nobody knew that routers could have vulnerability flaws before Mike came along, and it was a big deal because people don't patch their router software because nobody knew it needed to be patched. So people needed to know, and there was a patch available. Cisco actually knew that there, had like better stuff to send out to people, but they threatened Mike's employer and got them to tell Mike, you're going to lose your job if you tell this story. Well, Mike got on the stage at Black Hat, wearing a white baseball hat that said "good" on it, and he told the truth about what was true about Cisco routers, and they sued him. They sued him for copyright infringement, they sued him for trade secret infringement, and all kinds of stuff. So copyright infringement is, basically something that everybody who looks at the security of software has to do. You have to get a copy of the software, you have to make copies of it, you have to test it, you have to run it, you have to load it into memory. All of these things are copies, and all of those copies are governed by copyright law. Now, there's stuff in copyright law that's supposed to help you, like fair use and provisions for reverse engineering, and under Section 117, there's an adaptation right that you can use, but none of these work if you're not the owner of the copy or if you've waived those rights with the EULA, the license, the software license. So we have all these cases where they said, well, this is licensed software, you're a licensee, so you don't have fair use, you don't have 117 rights, and you can't do reverse engineering. That's out of the question for you. We managed to settle that case in a 72-hour slog with the lawyers for Cisco, but Mike returned home to his territory in Atlanta to find that the FBI was investigating him as well. And he had to hire, I was free, so that was nice for him, but he had to hire a lawyer in Atlanta to help shepherd him through the federal criminal investigation for him having done this research as part of his job and then telling people the truth on a public stage. So the EULA is a real problem in this area. It creates extreme legal risk when you have a world where everything's governed by copyright law. He was also charged with misappropriation, or claimed misappropriation of trade secrets, and the idea being that if you violate the EULA in order to determine information, then it was not a legitimate means for discovering the trade secret, and you're not entitled to the defenses under trade secret law. So poor Mike Lynn. Mike eventually got hired by Juniper, which is the competitor to Cisco, and he does still reside in the United States. I think he's still at Juniper. So, these private contracts by companies that have their own interests in disclosing software basically are interfering with rights that Congress put into the statute, not that robust rights, but rights that Congress put in the statute to try to protect people who are doing this, not this kind of work, but could protect people who are doing this kind of work. And those are just waived by this private contracting. Then we have probably one of the most hated laws, which is Section 1201 of the Digital Millennium Copyright Act, the anti-circumvention provisions. And, these have been used to go after people for all kinds of reverse engineering things, wherever people have tried to put some technological measure that stops you from looking at the code. There are some security researcher exemptions under 1201 for, you can't circumvent, and there's a ban on circumvention tools, but there are some security researching exceptions, but the exceptions are extremely narrow. You have to have authorization, and I've already talked about why authorization doesn't work. And it also has to not be copyright infringement, and I've already talked about why it arguably is copyright infringement. So what other things have happened as a result of Section 1201? Well, there's all kinds of cases. In 2010, I represented a hacker named Barnaby Jack who had discovered that a way that you could make an ATM machine basically spit out its cash drawer and spew cash all over the stage, which is an awesome, visual for a talk. And he was threatened by the ATM manufacturer. They didn't want him to do this, and they claimed all kinds of copyright and 1201 claims against him. And we had to, look and see whether any of these things, you need to have lawyers to look and see whether any of these things were allowable under these very narrow, exceptions from under DMCA. In 2008, I represented 3 MIT students who had discovered an attack on the MBTA card for the subway system. And MBTA sued them and said that they had, weren't allowed to disclose this information. And they wanted to, there's an exemption now that the Copyright Office issued under 1201, but for security research. But again, it's really narrow. It has to be lawfully required. There has to be no other criminal, no other law violations and any of that. So all of these exemptions are really basically useless for security researchers. And 1201 has civil and criminal penalties. In the MBTA case, the kids wanted to do a talk at DEF CON